Is it appointment or dismissal?
Dismissal. It's dismissal from service.
Any stay?
There's no stay.
But they are out.
Lordship.
They've been out of service for so long.
Yes, Your Lordship. Lordship, just a 2 weeks time because this senior counsel is occupied. He has a hearing, Your Lordship, before 2 weeks. Your Lordship.
On prayer made by the petitioner seeking adjournment on grounds of personal difficulty, the same not being objected to by respondents. This is matter after 2 weeks. So 14 to
20.
May I please, Your Lordship, I beg to mention item number 22, Your Lordship, as Mr. SD is on sanctioned leave, Your Lordship.
you are for
I'm for the petitioner.
petitioner. On prayer made by petitioner, this is matter of 2 weeks.
Similar prayer for item number 25, Your Lordship.
Appeal.
Yes, Your Lordship.
Lordship, 25 is a POCSO conviction. He's on bail, so it would be for the benefit of the appellant if the appeal is heard, Your Lordship.
On bail. What is the sentence imposed?
Sentence is, if I can recall,
5 years, 6 years,
2
below
years,
7,
2 years, Your Lordship.
below 10.
2 years, I think 2 years only, Your Lordship. 2 years only.
2 years. How long has he served? What was the period set off?
No, Your Lordship, he's on bail.
Oh, what was the period set off? He may
he
have
was
been
on
on
bail
bail.
here, arrested
Oh, right
on
from the
bail. Yes,
inception.
Your Lordship, yes.
Okay. On prayer made by the appellant, place this matter to 3 weeks.
Much obliged.
Bye-bye.
May it please your lordship. Lordship, I beg to make a mention of item 5.
Yes, Ms. Tell me.
Lordship, both parties were supposed to file written arguments in this matter. Lordship, I'm praying for some more time.
I think too much indulgence has been, given in this case.
Lordship,
You see, I agree. This matter has, has a very, firstly, a checkered history. Number 2, it is voluminous. Number 3, I must have forgotten what has been submitted. But the fact is that the councils are not helping the court. You should have been prompt with your, your reply, or whatever has been directed to you. Filing of a written argument will not take time. It should not actually, but considering the fact it's a 2013 matter.
Lordship, half of the written arguments ready. We only have the compilations that we've made previously, Lordship, that we filed in this before the court. There are 3 compilations, Lordship, which are voluminous. They're all case laws, Lordship. I'm praying if a week's time may be given, Lordship.
But there's only a single point issue to be decided here. Whether you are entitled to the pensionary benefit or not.
Lordship.
Please ensure no more adjournment.
Lordship.
How long?
Lordship, 1 week's time.
1 week. Have you filed yours, Mr. Outside?
It is ready because I was not well. Yesterday also I did not come, so I could not file it. But I can file it in 1 or 2
Please do it simultaneously. On prayer made by the parties. This matter is adjourned, awaiting the filing of the written argument by all concerned. It is reiterated that this matter is a long pending matter, and this court would call upon the parties to be diligent in pursuing the same. On premium, the same is allowed. This is matter up to 2 weeks.
Lordship. Lordship, a similar prayer for item number 6, Lordship.
Six or so, 2014 matter. What is the issue here?
Subsidies, Lordship.
Subsidy. Inadequate subsidy.
Yes, Madam. So they are basically contesting against the respondent union of India.
Oh, you did.
State is a party, but state is not contesting.
Okay. You could have proceeded with this matter, miss.
Lordship, I'm under very limited instructions with this matter, Lordship.
On prayer made by the petitioner, matter is adjourned. It is, however, made clear that no further adjournment would be allowed on the next date. 2 weeks.
Lordship.
As prayed for, list this matter to 2 weeks.
Lordship, a similar prayer for item 27.
You're for?
I'm for the appellant, the petitioner, Lordship.
Respondent?
But state is 1 and 2.
And I'm appearing for 3 and 4, my lord.
Any objection?
How long?
A week, Lordship.
What is the issue here?
My lord, this is 482 petition.
Exactly, but what
2
is
simultaneous FIR was filed. One was filed by the petitioner and one was filed by respondent number 3. Now both are under investigation. Now they have come before this court to quash the FIR filed by me.
So you are the person with the third FIR?
Not third, my lord. Second FIR.
Second FIR.
Yes. Subsequent FIR was filed. Incident is a family matter, my lord. Petitioner and respondent number 3, they both are blood brothers, staying in the same complex, and because of some property dispute, my lord, this incident took place. So they have filed an FIR. Just
Cross FIR was filed.
few hours before I filed the FIR.
But why, you see, brothers,
My
your
lord.
brothers, why can't you settle the matter,
I am ready for settlement. I have no problem. In fact, I have approached also, but it seems that they are reluctant.
You should, you see. After all, blood is thicker than water.
My lord,
You should.
I have made an
More often than not, it's do the legal part aside.
my lord.
It's not. It's unpleasant. If a family, comes before a court with their quarrel and the dispute, should have been settled at the behest of the elders or relatives or whatever, or even on your own. Try to see if you can settle the matter.
Lordship.
You impress upon your client.
Lordship.
I'll not note anything in that regard, but you do it.
Lordship.
On prayer made by the petitioner, list this matter up to 3 weeks.
Much obliged, Lordship.
Your Lordship, item number 21.
Yes.
Let it come after 3 weeks, Your Lordship.
What is required here, Mr.
Your Lordship, this is
The matter has been heard.
Your Lordship.
this has not been heard. This is the matters regarding this some action taken against the teachers, and then from the army.
Teachers.
It's a teacher matter, Your Lordship.
Which
Wherein my
school?
service
This
has
is in
been.
the
But why is the union involved here?
well,
Oh, but okay. Are you appearing for the
is Your Lordship.
as CGC?
SCGC. So in this case, Your Lordship, school matters, but some extent they are saying that government is involved in this matter. So I was asking for the instruction, but nothing has come out.
Which school?
Assam, Hillview School, Your Lordship.
Hillview School,
Hillview Secondary School. Assam Rifles.
Not
Run by the Assam Rifles?
no, not Assam Rifle. No, no, Assam Regiment Center. Inside there are Assam Regiment Center.
Okay, okay.
It is not Assam Rifle.
You are respondent? And you are?
And I will be for 4.
4.
So in this case, I have just given this instruction also, but now nothing has come out. So that's 3 weeks. If it is not come out, then
Termination?
No, Your Lordship, here my service has been treated as contractual even after serving for 20 years, Your Lordship.
Now I recall. Okay. But you're still in service?
Your
stay in
Lordship.
service.
Okay. On premier by the respondent 4, not objected to by petitioner, place this matter after 3 weeks.
Much obliged.
Mentioned.
Not
Lordship, there's item number 8.
Item number.
The senior who's conducting the matter for the petitioner, he was indicating that he'll be busy in court number 2. So
you're-
you'll ask for time, but
you're-
you're keeping quiet.
I was not informed, Your Lordship. So.
What is this?
This is regarding that Hima right in South. Creation from Sardarship to Sameship and Sameship to...
So you're putting words in a remote.
Yeah, I was surprised. I mean,
Yes, miss, tell me.
Your Lordship,
What
I
is
was
your
not
stand?
informed by my senior, so Your Lordship.
So we'll take it out then. Let it come.
Also, Your Lordship, I'm not ready today. If maybe fix will do it because every now and then one of the appellant always seeks for time.
A 2017 matter.
Your Lordship, even I'm eager to do it.
You are for
I'm for the private response.
private response.
I'm for the state formal party.
What is this matter about?
This is with regard to the restoration of lost stateship, Your Lordship.
Oh, that Sardarship into
After 150 years.
the same ship.
as
Conversion.
well during the pre-British, it was a Sameship. Then during the British regime, it became a Sardarship. Then we have
Restored back to its original status, Your Lordship.
a Sameship. Now they are challenging that decision of the district council.
So you have to enlighten this court on
Very ticklish matter.
on the difference between Sardarship and same ship and Lingdorship, whatever.
Sardarship, they are British areas. When you talk about ilakas and Sameship, they are same ship.
What-
25
So
Khasi
what's the
states.
difference there? Is it with regard to administration or regard to election, or what is it?
There's a lot of difference because when it comes to Sardarship, it is by adult franchise election. Anybody can become a Sardar. When you talk about same ship, then it has to come from a particular womb or corps. It's a very
And there's a term also of the post to be held, Your Lordship.
In Sardarship?
Sardarship is 5 years.
Oh, Sardarship is 5 years. Fine. So we should dispose it of. Yes. You are not ready
Not ready, Your Lordship. We may have it after 2 weeks, Your Lordship.
on permit by the petitioner. Place this matter for 2 weeks.
Much obliged.
much.
On supplementary cost list, item number 1.
May I please, Your Lordship? Your Lordship.
Yes.
Lordship,
Yes,
this
please.
matter
What
is
I
in
do?
fact infractuous because the election of the regular same has been conducted and accepted by the House. Now, if they are aggrieved by that election process, they have got alternative remedy if they so advise. There's nothing, no affidavit, I think, required to be filed. All other matters have been withdrawn. So far, the same subject matter is concerned.
Yes, miss.
Your Lordship, we are waiting for instruction. We have actually submitted the same or stated the same to the petitioner, and we waited for instruction. And in the next day, we will take steps, Your Lordship, as per the instruction.
If the matter has become infructuous, then it has become infructuous. What instructions are required?
As of now, no such
You are
instruction.
challenging the election of the same.
Yes, Your Lordship.
No? Same now is in place. As Mr. Kanta has submitted, if you are to assail or dispute the election of the same, there are other alternatives or forums. As far as this petition is concerned, it's pointless to.
Doesn't survive.
Your Lordship, I maybe come with a fresh instruction for my seniors at least in the next day. As of now, no instruction as such, Your Lordship.
So we'll list it tomorrow.
Sure, Your Lordship.
On prayer made by the petitioner, list this matter tomorrow.
I do oblige.
Item number 4.
Yes, Lordship. I am the petitioner in this instance case, Your Lordship.
Yes.
Your Lordship, here in this case, when I made petition in this case, Your Lordship,
Yes.
I was having the limited prayer. This, may come this first of all prayer, Your Lordship. What's the prayer meet? Then I'll come to this here. In the premise, it is therefore prayed that you, Lordship, receive is to admit the petition, issue rule, and call for the record, issue notice to the respondent as to why it minimize any other writ should not be issued, direct the respondent to release their salary as per sanction of the in favor of the petitioner forthwith, they draft account fee check along with the interest 12% per annum from the date of disbursement of the government fund to the city school. Further, be pleased to was the letter number dated 33/2015. So my main grievance is there too in this letter. issued by the Secretary Horizon Government Aided Secondary School, which is not in conformity with the Honorable Court order as well as the government order passed time to time on awarding the cost upon the respondent for misleading statement before the Honorable Court. And after hearing the parties, yes, then after this I said even I have to give my salary as per pay scale whatever earlier. So here you will see nutshell of the case, you will see. There was earlier lots of litigation. So petitioner here, you will see, he was appointed after following the due process in 1994. Thereafter, you will see,
where is the appointment letter?
Appointment letter I have given in compilation, you will see.
No, you have annexed.
So you will see, regarding appointment, we are not having any this. Compilation.
You were appointed on
1994. It is in my writ petition, page 23.
(1994).
1994.
As assistant teacher.
Yes, Your Lordship. As a science teacher, Your Lordship.
Yes.
So thereafter, Your Lordship, I was serving peacefully, and then I was having my salary from this managing committee. Whatsoever they are awarded to me, I was not having that much knowledge about it. That I was thinking that this is a private school. Whatsoever they are given, it is all right. And in between, they have appointed some other teacher also, and they have been released. And whatsoever they given me the salary, I was happy about it. So whatsoever
when you were appointed under the contract of appointment, was any specified amount,
So you will see, I'm coming later on.
Given to you as salary.
So you will see whatsoever, and subsequently, when I came to know that my salary is less, then I came to know this government is giving me the pay scale, and accordingly, when I just raise alarm, then they are paying to me as per scale of pay.
Okay.
And it was
you have been appointed in the sanction post.
Yes, Your Lordship. So after this,
that is a post which is created by the government.
Yes, Your Lordship. And the salary whatsoever used to come in the name of the school and in my name, this proof also there. And there is the instruction that given to me. In between whatsoever, Your Lordship, there may be some hidden agenda. They have appointed the respondent about 12 here. So it was not known to me that it is their hidden agenda. All of a sudden, in 2002, they have terminated to me from my service. So I approached before this court and given the stay. Then again, managing when that I am in the additional post, this also has been stayed by the High Court. So subsequently, final order has come up. When the final order has come up, then I have been reinstated. And this there was stay orders in continuation of this order whatsoever passed. So subsequently, whatsoever, when they are paying to my salary, then they are not paying according to whatsoever I was entitled. Even my area also didn't make payment. They have given some extra others. Again, I raised the objection about it. They didn't make payment to me. Then I approached before this Honorable Court. When I approached this before this Honorable Court, then they came with a plea that they'll be paying about it. So then also it is just keep aside. Subsequently, you receive, I filed another application to make payment of mine as per my entitlement. And this Honorable Court has passed, let it be considered by the authorities. So when they have passed considered it, they are not paying to me. I approached before this Honorable Court by a contempt petition. So when I have filed a contempt petition, to dispose the contempt petition, the respondent authorities come forward that I am entitled only for the amount whatsoever given here, you will see in my petition. You will see page the page 87, you will see. 87
Page?
onward. Page 87 onward.
87.
Which I have challenged in this order, you will see.
'89 is the type copy.
87, 88 and 89 is the type copy, you will see. And 90 is the type copy of 80.
What is this page?
So here you will see, in this case, they have agreed to make payment of 37,500. They are saying it is my entitlement from 1997 to up to 31st/5/2009, and they have given the breakup. And against this letter you will see, I am agreed because they have given the statement here totally false. Somewhere you will see I got this 4,250, and they are saying this I was entitled for 1 month 1,500. Somewhere they are saying nil, but I got the payment from the government. So if it is so, this if I accept this statement, you will see it is correct, then I will be entitled to this amount of rupees 37,500 only, and whatsoever amount I have drawn from the government, sometimes government is given, sometimes managing committee given, then I have to return this money. So that's why I will say I am not accepting this one. But here area of salary I am entitled about more than 3.5 lakhs. But they make the calculation, this much amount is entitled for me. So now after telling this petition, you will see, then they are coming with some other material. Just I was even terminated, and my service is not regular. So many aspects now is given. So my contention there, you will see, earlier when they have terminated to me in 2002, I have SL this action of the state authorities. After this, you will see, order was passed by the current single bench. State government went to the division bench. When the state government went to the division bench, then also they recognized my service. Even they stated this, I am only the teacher in the school. Now in this case affidavit, you will see, they are not saying anything about it, just taken the contradictory statement and difference done by the state as well as the managing committee. So had it been, you will see, today's position is correct, the officer who filed the even writ appeal against the order of the single bench, what was the conditions, you will see? What could have been? So now in this case, I am before this court only this much. Government considered my appointment. I was
Mr. You have been you have been appointed to a post.
Yes, Your Lordship.
Was your appointment approved by the government?
Yes, Your Lordship.
Where is the
So,
where's the approval?
So approval here, Your Lordship, I am not having this copy here.
Why?
But Your Lordship, subsequently I was having this salary, Your Lordship.
Whatever the case may be, you see, first you see you have to establish the main, this the basic fact that you have been appointed as a teacher, assistant teacher or science teacher, and your appointment have been approved by the government, as has been done in many cases. So that has to be there on record.
So Your Lordship, in this case, the approval, if you are saying it at the moment, Your Lordship, approval, copy of the approval, Your Lordship. Now is the first leg of litigation. When they terminated and court is considered, that time also it was not. Even this approval is with the managing committee. So let the managing committee produce the record, Your Lordship.
See, approval of managing committee and approval of government are two different things.
Government approval is there because government has sanctioned the post. Government has given the advantage. Everything is done. So all that record will
see, Mr. Devra, if I understand correctly, there would be an advertisement. Some person would have applied for the post. Perhaps you are one of them.
Yes.
Then you are found qualified and recommended for appointment by the managing committee. On that basis, the government would give its approval for your appointment.
Yes, Your Lordship.
Thereafter, you would be considered appointed.
Yes, Your Lordship.
Whatever this, whatever dispute or controversy that arise later, that would be a different thing.
So, this matter should be with the
first proof that.
So, Your Lordship, it will
But
be the
who is appearing for the government?
Yes,
Have you annexed any copy of the approval?
No, my lord.
Was he approved as by you
My lord,
at the initial period of appointment?
it must be there, my lord, but we have not given specific reply or documents to that effect, my lord.
Because Your
Then
Lordship,
how do you prove his bona fide?
even
It's for the
writ appeal
petitioner to prove that
writ appeal filed by the
because we are disputing all the
even writ appeal filed by the state respondent, they admitted this I am the appointed teacher.
Whatever, you see, that we are not going to that. But what this court would like to know is firstly,
So Your Lordship, let me have some time, Your Lordship.
prove your bona fide
In
that
this
you
matter,
have been appointed regularly and approved by the government. Then on that basis we will proceed and see what is your case.
Your Lordship. Then I need some time, Your Lordship, because in this matter I didn't even ask because so many cases there and then.
It's an old matter.
Lordship, I just make a mention to my learned friend's submission regarding approval. Normally in the Garo Hills, when a decision is given, I mean a resolution taken for appointment, it is entire resolution is sent to the inspector of schools. And inspector of schools on the body of this resolution makes approved and it is returned. So I think approval is of this nature.
Whatever. You see,
And that
it
we
could be.
given.
It could
We have
be in
given
that.
our
It could be in that nature.
Yes, Lord.
It could be in a form of an approval letter. Whatever, but it has to have the sanction of the approving authority.
It is there.
Once that is proof, then there's no dispute. Do you have a copy, Mr. Chaudhary?
Lordship, we have filed our shock cause to the writ petition on 29/11/2019. There it has been stated. Lordship.
Yes, Mohan.
In fact, my lord, her status as a science teacher is in dispute, my lord. There is another teacher who is claiming that over the same science teacher's post, my lord. So there is a claim and counter claim, and it is upon this that the managing committee and the state is finding difficulty in accommodating her. And moreover, the post is also transferred, my lord.
Her or him?
Lordship,
Private respondent.
No, we are not talking about private respondent. We are talking about the petitioner here.
Petitioner is a male, but the private respondent is a science teacher.
Whatever the case may be. First, let us confine our query to the status of the petitioner.
Petitioner.
Whether he has been, duly, his appointment was duly
That
approved.
is disputed, my lord. He is not a science teacher, my lord. That is what the government is also stating, that he is not a duly appointed science teacher.
Okay.
That is what has come to our affidavit, And if and when I read my affidavit,
If that is disputed, then
No, Your Lordship, it cannot be disputed because of
it doesn't matter.
it cannot be
It
disputed.
doesn't matter, Mr. Devnath. You prove your case. You prove it.
Your Lordship, this regarding this approval matters, Your Lordship, I have to take the instruction in the matters, Your Lordship. Approval definitely is there, because without approval, government will not pay, and will not sanction the name of the teacher without approval, Your Lordship. And I am having this matters of this.
Lordship, what I had submitted, Annexure B is page 34 of our school's affidavit in opposition. It is there.
What dated?
Detailed. This is we have given. Page 34 of our affidavit in opposition. First affidavit.
When did you file your affidavit?
Pardon? Filing date is 14/9/2015. And this is running page is 34.
Yes, ma'am.
What I had submitted, that approval is given by the margin of the resolution. It is the left side. Your Honor.
Just a moment.
Annexure B. Page 34.
34?
34, Lordship. Of course, Lordship, I beg to submit here. This is not the approval. This is the appointment of Samir Reza, who has been appointed regularly, and the service of the writ petitioner was terminated. Yes, it has been terminated, giving him an offer that type copy will be a very readable, Your Lordship, 37 page. That after his removal, he has been offered that if he is interested, he can continue as an ad hoc science teacher. Now, my friend, the writ petitioner here, he has acted upon this appointment. Now, after acting upon as an additional science teacher for long 2.5 years, more than up to 1998, can he come before the Honorable Court that I have been wrongly such and such? Once you have accepted the position as a fait accompli, can he? The entire writ goes on that. Not only that, Lordship, I don't like to open, let my friend produce it. But I am giving the resolution dated 15/3/1995, by which his service was terminated, and in his place Samir Reza was appointed, and he was offered that you may work as an ad hoc teacher with a salary of 1,000 rupees. Now, if we make a comparison, at that time salary was regular ad hoc grant for science was not even 5,000. So he was given initially 1,000, after 1 year 1,500 as an additional science teacher. Additional science teacher. He has acted upon. Lordship, he has accepted the salary also. If your Lordship goes to page 39, Annexure C, 1 to 3, there are all the months mentioned here that he has taken 8 months salary together. Kindly see that Annexure C, 1 to Annexure C, 13. So 13 months he has taken. After acting upon, after accepting the condition as fait accompli, can he come? This is the basic question comes. He has agreed. That is, his service has been rightly removed from service. And that has been approved by the Lord and Inspector of Schools, Tura. That is the approval of the resolution, Lordship. Appointment letter too already we have given. In the writ petition also
Your
given.
Lordship, if you finish, then I may just simply
You have not finished. I am just helping the Honorable Court that this Matter
No,
is
this
dragged
matters,
for
Your
the
Lordship,
last
when they drag
2002
it,
to
Your
up
Lordship,
to 2020.
now Your Lordship, just simple, Your Lordship, when one is coming in gap, if Your Lordship in person is appointed following the due process, how he will be terminated? Whether anything is given by the managing committee that I have been given the opportunity and after this I have been terminated from the sanction post when government approved to me, and sanction even the government has considered it. What is the show cause? Let them produce the show cause, Your Lordship. If they produce the show cause, I have given the reply.
Therefore, you
on
see,
the,
it is
so
therefore it is very important to first prove your bona fide that you have been appointed against a regular post, or sanctioned post, whatever the case may be, and your recommendation was approved by the government. As far as the school being a government-aided school, so
It's partially granted.
Once you prove that point, then we will look into what Mr. Chaudhary has contended, that you have been terminated, offered another post in lieu of your present post. All those things will come later. Whether it was done legally or not, that would be that would be
We are ready.
looked into.
Even when they are saying this, I have been terminated. Managing committee was not there. Even I have given this one.
That is wrong. That is wrong. He is going, Lordship. When
Your Lordship, when I am
Please
saying,
wait, let me
Lordship,
finish.
yes.
No, I will not catch you out here. This is very important thing you have raised. When
Definitely
the
it will come
inspector
up.
of schools, suspended the committee went to Guwahati High Court from principal seat. It was set aside. Initially, it
Your
was
Lordship, in the reply given,
state,
it may be.
state. So
Your
this
Lordship,
will not. This
Your Lordship,
already.
in the affidavit they have given, it may be. Not
Lordship,
sure,
his
maybe.
case is very much of civil nature. Let him go to the civil court because all are full with disputed. All disputed.
You
So
listen,
better he may go
when
to
I have
civil
given
court,
this matter government order,
cross-examination
how
will
did
be
you
there,
disputed?
exhibit of documents will be there. It is a very
Because if facts are involved, then
disputed
it's a
question.
different.
No, you listen, when this
So,
matter is
Mr.
government
Devnath,
fund is there.
let's
What is the government fund?
First-
Government
first-
gives fund only to the school.
first you
School is
come-
the appointing authority, disbursing
Mr.
authority.
Chaudhary,
Your Lordship.
let Mr. Devnath come with the
Yes, Lordship.
proper
Lordship. We are ready,
instruction.
Lordship.
So we'll take it up after 1 week.
So, you listen, it will take some time, you listen, this I have to.
Lordship.
If it is not with the petitioner, then he have to collect this one. You listen.
2015 matter, I don't want to.
2015 matters, you listen, and now this matters, if you have approval letter, then he have to collect it, you listen.
Now, what he is raising, let me also refer to the school managing committee. I think they have so many
you can
petitions
come-
are filed,
you
Lordship.
go-
We have
you-
given shoppers.
Whatever.
Miscellaneous petitions.
If you have not put that on record, you
Lordship,
can.
we have filed a written argument as far back as 2019.
Forget about written argument. That
If
comes
need
later.
be, then what my friend is now raising, I will try to revise it if need be. Much obliged, Lordship.
Let counsel for the petitioner, after proceeding with the argument, and in the midst thereof has made a submission that has on a query made by this court, made a submission that this matter may be adjourned for the time being to allow the letter counsel to be instructed by the petitioner as regard the factum of the government's approval to his initial appointment. On pyramid, the same is allowed. List this matter
After 4 weeks, yes.
4 weeks.
Because if it is not there, then it will be approved to this authority to collect. And managing committee may not give you lordship.
He will make a RTI application.
Your lordship, managing committee, they are not cooperating, and managing committee always they are misleading to me. Even some documents they are saying that it is not available.
Petitioner is doing what is not expected, Lordship.
Mr. Chaudhary has said that he will also go through his record. If it is available, he will bring it up.
We'll give it. If you...
It can be procured from any source.
So that's
From
why I
our
was saying
source,
that
it is
we have
there,
to bring
we'll
the record.
We'll
to
give
this.
it, Lordship.
This is matter for 4 weeks.
Much
Item number 9.
Lordship, may kindly take up this matter at the end of the board. The learned DSGI is on legs.
What is required here?
Your Lordship,
Or recruitment rules?
that recruitment rule in the first order 23/2000, Your Lordship passed an order, this Honorable Court, within 8 weeks, way back in the March 2020, within 8 weeks, you need to formulate the rules. On the last occasion, after my Lord 2 years, 2023, after Your Lordship passing one after another order, then on the last occasion, additional CGSC placed an order before Your Lordship, a letter, wherein it is stated that recruitment rule already, Lordship may look into Your Lordship's last order, wherein Your Lordship asked
Yes.
to produce the...
It has been approved since
My Lord.
26/7/2022.
My Lord, fortunately or unfortunately, day before yesterday, from the website, I have downloaded this recruitment rule. This recruitment rule in the cadre of warrant officer. And we became a warrant officer in 1997 by way of redesignation as entry gate. And it has no bearing, my prayer, everywhere, their affidavit saying the recruitment rule posts were sanctioned way back in the year 2003, post of Naib Subedar, 13 post of Naib Subedar, and they have in their affidavit, they have specifically admitted that as soon as the recruitment rule is approved, will be given the promotion. It is their affidavit. There nowhere, no denial. Now on the other day, Your Lordship, he has, and I am showing that recruitment rule. It is a recruitment rule of warrant officer. I have, my Lord, highlighted, Your Lordship, for Your Lordship's convenience.
Give them a copy.
My Lord. And this is not the recruitment. We are already working from 97 as warrant officer.
You give me 2 copies. The same.
My Lord, I think it is same copy, my Lord. I have, my Lord, highlighted 1 copy. I have highlighted, my Lord. It has got nothing to. We are working in to the post of warrant officer. And we have approved way back in the year 2018 this court.
Yes. See, now you say that you are already in the cadre of warrant officer. You've been, were you promoted, or were you remastered, or were you, what is?
No, that is Your Lordship have dealt in or the last.
Yes, that's what I'm asking.
Dealt
How?
by way of redesignation. It is given an entry grade.
Okay.
Entry grade from 1997.
That is true.
97. Now our promotion is due. Our promotion is due in the cadre of Naib Subedar. These posts were sanctioned in the year 2003, Your Lordship. This Naib Subedar, 13 posts of Naib Subedar were sanctioned. 1 post of Subedar Major. So we are repeatedly representing before these authorities. Then they are saying, my Lord, page 79, Your Lordship, as soon as the recruitment rule, it is under, we have already taken up the matter with the ministry. As soon as the recruitment rule is framed, you will be considered for promotion. And that is in their affidavit in opposition, Your Lordship, para 2, page 2.
Anyway, so now we have the recruitment rules. These are the recruitment rules.
No, this is not the recruitment rule. It is not the recruitment rule of Naib Subedar.
No, this
is not a recruitment rule of Naib Subedar.
Naib Subedar is not the entry post, is it?
No, we are seeking promotion. My Lord, my specific prayer is for promotion to the post of Naib Subedar. Specific prayer. Exactly. And that, yes, my Lord, and Your Lordships, even March.
So, you see, now, in these recruitment rules,
it has got nothing to do with us.
There should be a provision for promotion.
No, there is no promotion for promotion. This is a recruitment rule for promotion to the post of warrant officer. Warrant officer.
Mr. Dr. Muzika, it appears
that
repeated requests have been made to you. You have not produced. Finally, Mr. Chanda has.
No, they've sent me On 31st March, my lord, just 4 days back. What I see
could have
is something different.
Could have downloaded it from the net. He got it from the net.
No, I got from the department. Well,
Is it different? Compare it with what Mr. Chanda has produced.
Is that?
This is warrant officer, my lord.
Same.
Warrant officer.
Warrant officer.
It is nothing to do with our prayer. Your lordship's order passed in March 2020. There your lordship observed 17 years. For 17 years that order is 20 March.
Yes, I remember that.
That order, and now they have produced before your lordship. And for 2018, we are before this court, your lordship. 2018. I have submitted my written argument. I have compilation of judgment. Lordship may pass.
How would these rules have a bearing on the case of the petitioners?
It will not, my lord. But what they told me, my lord, that the rules have been framed, matter can be disposed of. And fortunately, lordship didn't close the matter and asked me to submit a copy. But when I get a copy, my lord, I was also surprised that this is something totally.
I am also, my lord.
That's what he is.
On the other day, your lordship passed an order to produce the
rules.
Yes, because what has been submitted is
my
that
lord,
these
yes.
rules will have a bearing
Fortunately or unfortunately,
even by observation of this court.
My lord.
But now what is required is how the promotion will be affected from this warrant officer upwards.
Yes, yes.
To the next higher level post. That is not there in this.
That is not there. But if that is not there, we go by the
yes, my lord.
natural progression.
Yes, seniority. Normally, my lord, there is one judgment I have given. If there is no rule, there is a judgment of the Supreme Court, then you can go by seniority, subject to rejection of unfit. Subject to rejection, that judgment is there. If there is no recruitment rule in any government department,
well, actually, what happened, my lord,
that is there.
The department
they could have done it.
Department is not able to reconcile with the various orders passed with court, my lord.
Okay.
That is where the difficulty is. As I submitted, my lord, we have to implement because of contempt, my lord, some of the directions. And those directions are not in tune with the scheme, my lord.
My humble submission, my lord, this with due, because this is not the case, my lord, here. Yeah, sanction is made in 2003, your lordship. They admitted in the affidavit in opposition.
Mr. Chanda, can you help me?
My lord.
Can you just refresh this court on
your
on the brief facts of your case?
My lord, yes.
And
yes.
Dr. Musika can respond to that?
My lord.
And then we'll...
My lord.
Maybe I'll...
Definitely.
Post this matter for judgment.
Yes, my lord.
You filed your written argument both sides?
We have not filed, my lord. Because this was only, if the rules were there, my lord, there was no need of any adjudication, my lord.
My lord, there are so many judgments I have placed, compilation.
There are no rules.
But rules, it seems, is not.
All judgments are dealt with this issue.
Exactly. So in the event of there being no rules, then we have to look for other alternative. What is the alternative mode? But what is due to them has to be given to them. And if there is a post in the rank and cadre of Naik Subedar, they have
Subedar and Subedar Major. Next promotion will be Subedar and
Naib Subedar.
After
okay.
Naib Subedar, Subedar and
exactly.
Subedar Major.
So if that is there, then if there is no post and if they are stagnated or stagnant in a particular post, then the ACP, MACP scheme would come into the picture.
That has already been there.
So that is already there, so we need not look at that.
So probably, your lordship, from their affidavit in opposition, they admitted it. They admitted. I am reading that their affidavit, my lord. Only that person probably whole issue will be settled. They have stated. May I read, my lord, that person affidavit, page 2.
Para.
Well, page 2 of the affidavit, my lord, we have categorically stated, my lord.
I am reading it para 2, my lord. Sub-para.
Para 2?
Para 2. Para 4, sub-para, my lord. During the year 2003. I am reading it, my lord.
Yes.
During the year 2003, restructured Peace Establishment 2003 of Assam Rifles Battalions, Formation Headquarters and ancillary units were sanctioned by the Government of India, Ministry of Home Affairs, letter number so-and-so, dated 19/8/2003, number so-and-so, dated 23/8/2003. These are the date of sanction of vacancies, respectively. Accordingly, this is important, my lord. Accordingly, 13 posts of Naib Subedar, draftsman, and 1 post of Subedar Major, draftsman, were authorized. In Assam Rifle, an intimation of the same was circulated to all the units by the Headquarter Director General of Assam Rifles by letter dated 1/10/2003. Soon after authorization of the above post, case for framing recruitment rules for promotion of draftsmen of the force to the above post were taken up with the Ministry of Home Affairs and Department of Personnel and Training as intimated by the administrative branch. Headquarters Directorate General Assam Rifle by letter dated 7/2/2018, the approval of which is still awaited from the Ministry of Home Affairs. In the meantime, several representations from the petitioners have been received by the department during the past, wherein they have requested the department to grant them promotion to the rank of Naib Subedar Draftsman and Subedar Major Draftsman, as applicable based on the restructured Peace Establishment 2003 according to their seniority. It is pertinent to mention here that the post of Subedar Draftsman has not been authorized in the restructured Peace Establishment 2003. Thus, the question of promotion to the rank of Subedar Draftsman does not arise. The writ petitioners are actually eligible. They are admitting, my lord, we are actually eligible for promotion to the next higher rank of Naib Subedar Draftsman and Subedar Major based on their seniority, subject to fulfillment of other basic promotion qualitative requirements, but have not been promoted due to non-receipt of approved recruitment rule. Non-receipt of approved recruitment rule. So, sanctioning of post way back in the year 2003. We are now in 2023, my lord. After 20 years, recruitment rule has not been framed. After 20 years. Lordship.
So, Dr. Muziga, without the recruitment rules being in place, can they still be promoted?
No, that
if the posts are already there.
That is what the purport of the affidavit, my lord. We do not know what will be the criteria, how many years of service will be required for promotion, what are the other qualitative criteria, what should be the ACR grading, because all these things have to be taken into consideration. Unless that is there, my lord, on what basis?
I can reply.
I can just complete. So unless we know the rules, my lord, we cannot hold DPC, because DPC will consider all those factors, my lord. Now, my lord, the second more important aspect, my lord, these posts were sanctioned in 2003, my lord. My lord, earlier the system was that they were all riflemen, my lord. Then by promotion they become Havaldar. From there, by promotion they become assistant warrant officer, my lord. After this, after 2003, by the order passed by this honorable court, and while implementing that, all of them become, my lord, there are no riflemen, there are no Havaldar now, my lord.
They are all warrant officers.
All have become warrant officers, but the channel itself is disturbed, my lord. The entire channel of promotion is disturbed.
We go back again to that notification of
97. When that was implemented, my lord.
2210.
2210/97, my lord. When that was implemented, there is no rifleman, because the channel of promotion, these posts in my humble submission were created keeping in view the structure at that point of time, my lord. That they are riflemen, 3 years or 5 years they'll become draftsman, then Havaldar, and then warrant officer, then next promotion, my lord. Now 3 layers have been wiped out, my lord. All have become warrant officer, my lord.
Whatever the case may be, you see, even if all have become warrant officer.
No, my lord, supposing, my lord, why this has taken time in my humble submission, my lord. Earlier the rules would have been that 20 years of service or 15 years of service, my lord.
10 years, whatever.
And 5 years as rifleman, 3 years as this, 5 years as something like that. Now the entire thing has been disturbed at the bottom, my lord. All are from their entry itself, they are warrant officer, my lord.
My lord, because this is done, my lord, following the KK Dination judgment. This is done Following, because all central paramilitary force should follow the same norms, promotional avenues.
Department is not able to reconcile the cadre structure itself is disturbed, my lord.
But you see, Mr. Dr. Muzika, you have to keep in mind that this matter, even the court has observed, that the matter has taken 17 years for you to decide. 17 years is a long period. If you say that suppose had it happened immediately and they have come with a claim within the next 1 year, 2 years or so, then you could still, your argument could have been valid, that we are still in the process of reconciling the situation, and so on and so forth. But by now you should have, come up with some concrete rules, for example, the recruitment rules, which you have not done so.
And moreover, only some of them they've come, my lord, around 10 of them.
Whatever the case may be.
There must be in thousands, my lord, the warrant officer in this trade.
No, this is draftsman category. What my friend is saying, I don't understand. It is draftsman category.
Anyway, whatever the case may be, we are looking at the modalities. We are looking at what is required as per rules and regulation, or as per the principles and norms of promotion. I understand you need a basis for it, for which recruitment rules are required. But they are also equally.
Why is taking so much of time?
They are
or
also
whether
equally.
They want to abolish the section post also.
But they are also equally entitled.
The department
that
is
you have
entitled to
admitted.
maybe revamp the structure with the 13 posts to sanction that point of time when they were not warrant officer.
So these posts are still vacant.
Are vacant, but whether the department intends to keep this post or not, that is no clarity.
As and when they decide, it will be a different thing altogether. As of now, how many petitioners are here?
I think 11, my
11.
So they can be accommodated in those posts. Sans the rules.
But that can be, we have to go by the seniority of the incumbent.
Yes.
My lord, only some, I'll close, my lord. Some judgments I have given in support of this, our contention, my lord, where it was very elaborately dealt, and all the maximum judgments of the Honorable Supreme Court, your lordship. 9 judgments in my compilation, I have given 9 judgments, my lord. All regarding promotion, my lord. All regarding promotion.
What manner of promotion?
Promotion, because, my lord, warrant officer is the entry grade. It is by way of redesignation. It is by way of redesignation from KK Dination. KK Dination case, Assam Rifle.
That is acceptable.
Acceptable. So from entry grade till date, we have not received a single promotion. Now some are on the verge of retirement. Some are on the verge of retirement, my lord. So without any promotion, they will have to retire the grade where they were initially entered in service.
They joined as riflemen, my lord, they are warrant officer already.
Riflemen have been given the warrant officer, draftsman. Following that judgment, I have enclosed in the WPC.
That is settled.
They cannot say that they are not good. They are still riflemen. It's not the case, my lord.
My lord, those judgments, if your lordship, some highlight, I'll close, my lord. Some judgments I want to.
My lord, what I was doing, my lord.
That may be, my lord, this matter may be, your lordship pass appropriate order. Your lordship will pass appropriate order. My lord,
this rather than
my prayer is, specific prayer is for retrospective promotion. Otherwise, my lord, and in these judgments.
From when? Retrospective promotion from when?
From the post was sanctioned. And DOPT guideline is there, my lord. DOPT guideline is there. I'll show only DOPT guideline, your lordship. I'll not read DOPT guideline, Government of India. Because he cannot oppose the Government of India's instruction.
Post was sanctioned, my lord, when they are not warrant officer. They were still riflemen, my lord.
When did he?
My lord, what I was praying, my lord, because this is on framing the rules, my lord. That is the first basis of this. If lordship gives me some time, my lord, I can, because what I was under the impression that rules have been framed and matter can be closed. But what?
My lord, it is 5 years. We are from 2018. We are before this court, my lord.
At this point of time, what can you do, Mr. Dr. Muzika? What can you do?
One opportunity is given, my lord.
You have,
because I was not here last week, my lord. I couldn't get the correct.
Dr. Muzika, it's not you.
Maybe
we are not talking about you personally.
Monday also it is fixed, my lord. Today is
We are not talking about you personally, but the fact remains that it doesn't change the situation at all.
The situation will change
Except
because
if you
any direction to give from the date of sanctioning of the post, and this kind of situation will create a lot of.
On that plea or that contention, you have a right to counter that argument. That is okay. So the court will decide on it. What is valid and what is not. He has made a point. You will counter it. But as far as the recruitment rules per se are concerned, I think it's too late in the day to do it. You cannot just come up, you come by Monday, you cannot come with the recruitment rules and say that these.
My humble submission, my lordship may pass whatever order, your lordship, on the basis of his arguments.
Well, that's what.
This is very unkind.
You have said your whatever is required to be said.
Why Mr. Chandra
Give him a
getting
chance.
agitated, my lord? I don't understand.
It's not a question of being agitated.
Well, as if I have submitted to pass any judgment. Well, that's not the way, my lord.
That's not the way.
No, I am saying
I have the right to reply
my lord,
also, my lord.
everything is because they could not bring anything, my lord. Till day, as your lordship rightly said.
But there are other aspects of the matter which has to be considered.
My lord.
You have raised certain points. He would like to counter that. You should give him a chance to do it. If your points are valid and strong, you have nothing to fear. On the contrary,
If I may submit, my lord, the rules of promotion in our country is what, my lord? Seniority, merit, and merit comes seniority, seniority. Even that we don't know whether the promotion will be by seniority or by merit. Okay, we'll give promotion on the basis of merit and declare them all unmeritorious, my lord. But we must have the rules also, my lord. What will the criteria? How many years of service is required? Whether it be seniority, whether it be merit.
that is why you see, Dr. Musika, since you have not been able to supply the rules, point out what is exactly applicable to them, we go now by convention and precedent. So the court has to, approach the matter on that premise. Nothing else.
My lord.
So, my lord, because I have not submitted my written submission also, I have received their written submission, my lord.
Long back, my written submission was given long back, my lord.
So Monday then?
Monday.
Last.
We'll file written submission on that. No?
Either you file your written argument by Monday, because in fact I would like to get a written argument because I have not, I have lost touch of the matter. Mr. Chanda has filed his written argument.
Written argument and compilation of judgment I have filed.
Mr. Chanda is ready, my lord. Everything you can same just photocopy and give, my lord. But I have to prepare.
My lord, only one aspect, my lord. Only one aspect regarding the DOPT's, Government of India's instruction, because DOPT is followed by Assam Rifle also. In page 19, I have quoted the DOPT's instruction. Here says, a vacancy shall be liable to be filled up. I have given the quotation, liable to be filled up on the day of vacancy.
You have stated that in your written argument.
My lord, yes, I have given it.
Have you given?
I have given it.
Have you given a copy?
Given, my lord. That's his signature is there.
Fine.
I have
let Dr.
Musika
reply.
And in all the judgment, even your lordship, in some of the
There's only list of books. There's no written submission. There's only list of books is given to me.
Judgment दिया तुम्हारा दिया है. ये देखो ना.
Judgments are there and list of books only. There's 2 pages.
Take one more. I'm giving one more, my lord. In those judgments, here DOPT I have given the quotation. Here it says DOPT on the pretext of recruitment deal is under preparation. On that is in page 12 of my writ petition. I have given because DOPT they are bound by the DOPT. He cannot oppose the DOPTs. On the pretext of preparation of recruitment, you cannot defer the promotion. Besides, in all the judgments,
DOPT is applicable in CAT, my lord. I don't think they'll apply to some purpose.
You see, we'll go by the principles.
And in all those judgments, even says when there is no rule, you cannot hold up the promotion. You cannot hold up the promotion. You can, by executive instruction, you are to promote the persons, subject to seniority or whatever it is. So, in PN Pemachandan case, also I have stated that for the administrative lapses, government employees should not suffer in the matter of promotion, my lord. And in other cases, even drafts the recruitment rule can be acted upon in the absence of a approved recruitment rule. So all those 9 judgments and in the written argument, I have given everything, my lord.
So we'll take it up on Monday then. Last.
I'll answer all that, my lord. Post was sanctioned in 2003, my lord. They filed writ petition in 2018. 15 years. Why, my lord? They waiting? Because that time they were only riflemen, my lord.
That is why you.
He's arguing against him.
You set up your points of argument, and
I'll do that.
The matter will be considered.
My lord, whether only he will submit a written argument.
Not necessary for you to.
My lord,
not necessary for you to come, but if you want to, either you can do it or appear virtually.
My lord, because he will submit a written argument. I think.
Yes.
Whatever my written argument, I'll not make any further. Yeah, my lord. My judgment and written argument, Lordship will consider.
I have liberty to make some submission on the written argument also.
Yes, you can do that. You can do that. And Mr. Chanda, either you appear.
No, today he could have made these submissions.
But he has not filed the written argument. That's what his prayer is, to file the written argument and then elaborate on it if required. That's all.
Monday.
My lord, Monday.
Giving 1 or 2 extra days good for me.
What do you suggest?
I was under the impression matter will be over today, my lord. I was under the impression.
It would have been. But then, see,
my lord.
The court has
so
to
he's again.
The court has to be fair to all the parties. You see.
Give
them the satisfaction that they have presented their case to the fullest. Then leave the rest to the court.
Any day, my lord.
You suggest, Mr. Chanda?
My lord,
if you're not free on Monday, then Tuesday then.
18. On 18, my lord.
18, that's Tuesday.
On 18.
Dr. N. Musika, Laret DSGI, has submitted that the written argument on behalf of the respondent may be allowed to be filed in this matter. As prayed for, the respondents are allowed to file the written argument. It is, however, made clear that no further adjournment will be allowed in this matter.
Deeply obliged,
As prayed for, list this matter on 18th.
Deeply obliged.
Item number 10.
Mr. Bora aspiring.
Falling asleep.
I thought it is 30 actually. It was in the other court. Serial number.
What is required here, Mr. You have to get instructions, isn't it? Or what is required?
He had taken time to file the rejoinder. No, I don't want to file rejoinder. We can go for the hearing, final hearing, man.
Okay. So we'll hear the matter.
We can do it today also, and if
Today-
when is ready.
Today we have almost time, limited time.
We can take it up in the second half.
After lunch hours, yes.
So we'll take it up in the second half.
Yes.
Second half. So any other matter? Yes, Mr.
Number 12 is there with Mr. Chanda, madam. Pray for some time. Maybe on Tuesday we will be. Chanda is coming.
Tuesday? 12. Huh? As prayed for by the councils. This is matter on 18th. So Tuesday.
Wait, please, Your Lordship. I'm from the respondent number 5 in this WPC 455/2018. So my humble submission, Your
Item number?
13, Your Lordship. 13, Your Lordship.
Oh.
So can we fix
It's
another
also an
date?
old matter.
Yes, Lordship. No, because at 2 o'clock I have to go for my eye checkup here in Naraya, this fire brigade here, Your Lordship.
You are for respondent.
Yes. I'm for a petitioner, Lordship. I've already informed all the parties.
As prayed for by
Respondent 5, Your Lordship.
as prayed for by Land councils. This is matter up to 2 weeks.
Highly obliged, Your Lordship.
Item number 24, Lordship. The similar issue, Lordship, criminal revision. 24. Anantadev.
This is 24 and what is
24, Lordship. Criminal revision against the order passed by the POCSO court.
The conviction order.
Conviction order. I'm praying like if this matter
or
comes.
conviction order. As paid for by the learned counsel for the parties, list this matter after 3 weeks, 2 weeks.
It can come together along with the item number 1.
Did I say 3 weeks in the other one? 3 weeks.
Hello, Lordship.
May I place Your Lordship, item number 11.
Yes.
Kindly let the matter come up after 2 weeks, Your Lordship.
On prayer made by the parties, list this matter after 2 weeks.
My Lord, I'm appearing on behalf of the newly pleaded respondent number 4 in the item number 11.
Have you filed your power?
We'll be filing, my Lord.
Then you file your power. In the meantime, let it come up. Then you can make your submission there.
Please, Your Lordship. Your Lordship, I beg to mention item number 28, Your Lordship. Your Lordship, it's a joint request, Your Lordship, if the matter can come up after 3 weeks.
You are there, miss?
I'm there, in Lordship, for respondent number 6, 8, 9, 10, and 11.
Oh, this is that
Clubbing of matters, my lord. The clubbing of POCSO cases.
that matter connected with the
Yes, Your Lordship.
immoral trafficking.
Immoral
Is it?
trafficking.
On prayer made by the parties, list this matter to 3 weeks. Sasang tu ka. 10. Huh? Oh, yes, I think. So we'll take up the rest of the matter after lunch. Where's Mr. Bar?
Lordship, please wait. I saw him maybe outside, Lordship. This BC matter, Lordship. BC
Yeah,
matter.
I remember that.
His prayer is for unemployment allowance. Unemployment allowance.
Of course, if they are entitled to,
Lordship, because unemployment allowance, Lordship, it is claim baseless claim. Because the work orders are issued to them from time to time, Lordship. Depending on their on the basis of their resolution and demand for work. So we
but that 100 days has to be, is it?
100 days also, Lordship, that 100 days, we give them 100 days, but some of them, they don't attend the work.
Okay.
Some of them, they go for their personal work, for some other work, so they didn't get 100 days. Actually, we give them all 100 days only. And the wages also are paid to them immediately. There is no delay in payment of the wages. No delay. Because the payment is done digitally through a digital. He's outside, Lordship. Just
We'll take it
outside.
up later. Call next.
Item number 26.
Please, Your Lordship. Your Lordship, this is for quashing of the complaint case, Your Lordship, registered under IPC and also the Prohibition of Dowry Act.
Yes. So we'll take it up. Who's?
It's between private parties, I think.
Oh, private parties.
Private.
Subhashish and
He's not here.
He's not here. Today morning he came. I think he left, Lordship.
Petitioner is present. Respondent is not found on call. However, for ends of justice, this matter is adjourned for the day. This is the same after 3 weeks.
Right, Lordship.
Item number 29.
May I please? Well, when the petition was originally filed, at that time, the petitioner was the secretary of the VEC of Chirakata, which he is not now. Now, there were 104 job card holders who had not got job for a couple of years. So he filed for those people who did not get job for few days in a year. They are supposed to get 100. So they got less than 100. during the proceedings of the case, the respondent 1, 2, and 3 filed show cause, filed an affidavit in opposition. Earlier saying that they have been getting works, but not very clear that they have been getting works regularly for all the days in the years. And ultimately, the lists were called for. The list had come from the learned respondent side also, from which we had made the consolidated list. After that, the question arose from the respondent side regarding my status. Who am I to represent all? So thereafter, as per the order of the court, I filed an affidavit. First affidavit was filed to consolidate all the payment schedules. Thereafter, that affidavit, as per dated order dated 26 October 2022, I personally had gone to the village. There was a meeting held, and the job card holders had signed the papers authorizing the petitioner to represent them in the case. Thereafter, the latest happened is the respondents went to the village to hold a meeting, a report of which has been filed recently by affidavit. Here,
are there private respondents here?
Yes, I have received copy. It was filed on the.
Just a minute.
No private respondent.
But yes. Affidavit to bring on record approval of dated 22/9/21 certificate of election and report of verification dated so and so. That was filed by
No
you.
private respondent.
No, there are no private respondents.
No private respondents.
I was asking that.
Yes. Now here, this latest affidavit, it contains two parts. First part is regarding the announcement of the new VEC and who is the chairman and secretary. For that, we have no comments on that. The second part is unauthorized part. The respondents also went and tried to get the signatures of the villagers, asking them to compromise. That you compromise, take away, withdraw the case, otherwise you will not be getting any job in future. So they contacted me personally. Immediately I was in Nagaon. This is happening. I heard also what is happening in the meeting. Then I said, don't sign. So on the advice of their advocate, they did not sign the paper. Now that blank page has been brought to show that they have agreed not to carry on with the case. Nothing has been proved, can be proved by this paper, where no signatures are present. And actually, nobody has signed to say that they have not approved the leadership of the petitioner to proceed with the case on their behalf. So this second part is not acceptable, my lord. Now coming to the case at hand.
Have you filed a rejoinder to that?
Pardon?
Have you filed a rejoinder to that?
I have not filed rejoinder. The rejoinder, on the face of it, there's a blank page. The page number 9 of it.
Okay.
It's a blank page. Nobody has signed here. That means their approval or non-approval cannot be discerned from this blank page.
From this. Fine.
The petition originally was aimed at the
Mr. Pura had
payment
taken time to file the rejoinder on this affidavit, my
may
affidavit
file.
filed by me, but now he has declined.
Do not want to file. There's hardly
He doesn't
anything to
want
file actually.
Okay. We'll proceed. Please.
We had come praying for the unemployment allowance as given under Section 7 of the Act, which is a due, which is payable to us. We have asked for that, plus the payment which is payable to us as delayed payment, compensation for delayed payment of unemployment allowance. To support my claims for the unemployment allowance for the days when we have not been given any job, I had come out with two cases only, since it's a new act. Recitals are very rare. Two rulings only I've found.
See, Mr.
I have
Bora,
already submitted those.
First, let us be clear.
Yes.
You have claimed that out of the 100 days that you are supposed to get work, you are not getting. maybe you got any part of it or none of it.
Yes, full 100 days we did not get.
For which there's a provision to claim for allowance.
Allowance for those days, deficit days.
Deficit days. Now, in such a situation, what is the procedure? Are you supposed to petition the authorities, or have you come directly for the court?
No, we have not come directly to the court. We have gone under section 14 of the Act also to the project officer. I have made a mention of it in my petition also. First, we had gone under section 14 to the DC, who is the district program coordinator.
Okay.
Because he under clause 3G.
So
to
you
redress grievance of the applicant. He has the power.
You have annexed that
that I don't know whether I have annexed. That I have not annexed.
Then how do you know that you have followed due procedure?
We had made an application only from the secretary side to the DC as the program coordinator to look into the matter.
Okay, maybe let us take it that is a compliance of section 14.
Yes. So and there was no response actually.
There was no response. Is there an appellate authority?
And verbally, these people had been meeting the BDO almost every day.
Hey,
that happens as usual. They go to the BDO because most of them are illiterate people.
Anything that has transpired verbally cannot be taken on. Cannot be taken on record.
There is nothing on record to show that he had approached the authorities, Lordship.
You must have either you affirm it by way of an affidavit, which
yes, my lord,
has
actually,
to be refuted, or
I'll produce that by an affidavit.
Bora, you understand the scope of judicial review, especially under 226.
I'll annex that. I'll produce that communication.
Only if there's an aberration in the process, due process, then the court can interfere.
Yes,
but if you have not followed due process, you cannot just short circuit.
Jump to that is true. That they have not. So I'll produce that. I'm be given one more day time. 2 weeks time. I'll produce that by an affidavit, my lord.
What have you impugned here in your petition?
Nothing has been impugned actually. Yeah. We are just claiming the due that we have not been given job for this. That means the authority have not followed the act.
See, Mr. Bora, in that case, you see, you have wasted your time and the court's time for almost 7 years.
That communication I'll file by an affidavit.
Court's time 7 years on that. Because what happened is, you know very well, I don't have to teach you, you have to teach me, in fact. If you have followed due procedure according to the provisions of the Act or in accordance with law, if there is non-compliance, if there is an aberration somewhere along the line, then your resort would be to approach this court.
Yes.
For which you have to impugn. See, you have to impugn either an order or a direction or non-compliance, whatever the case may be. Or just simply coming and say we have not got it, and then the court
No, we have come not impugning the particular order of authority, but the entire authority's non-compliance of the provision of the Act. We have come that way because non-compliance of the provision of the Act itself gives rise to a writ of mandamus. The petitioner gets a right to apply for writ of mandamus because the provision of the Act has not been followed by the authority.
Also, you see, that is also only if you have exhausted all.
The machinery has been made in such a way because the villagers, my lord, villagers are, most of them are illiterate. They don't know reading and writing. They have to come to the BDO's office. That has been followed. The BDO makes the report to its higher authority. That has been the procedure going on here all the time because they are illiterate people. Now we have to have some soft corner for the illiterate people also. They do not know the procedures. Now they have found, now it's not, the procedure is within 15 days of their lapse, he has to apply. Now that cannot be there because it's a lapse of 5 years. that the authority have not followed the section, the provision given in the Act. That is the grievance actually.
That is okay. You see,
there is no impugned order as such.
As far as the lapse from the side of the authority is concerned, that can be looked into. But
That lapse only I have come to the court.
We have come to the court. What have you done? See, you say that you are illiterate, understood. But the fact that you see in this day and age, there must be somebody who should guide you. There must be somebody who, perhaps the petitioner himself.
The thing is that this is not a case of 1 year that we will go to the procedure and come back. 2017, there was no work given at all. Not even 1 day. 2017.
Is it documented?
Yes, my lord. 2016, some work days were there. 2017, no work.
I have replied in my affidavit. The work were issued after the election of the new of the VEC. After that, we have issued the work time to time.
That is not the
But prior to that,
the Act does not say anything that if there is no new VEC form, new job will not be given. Now the Act says this 100 days of work has to be given. Now for 5 days, 5 years, when there is a lapse in the number of days given, that is the grievance actually. The authorities have not followed the law.
Let us do one thing.
There is no impugned order of any sort.
Let us do one thing. At this point of time, if you want to, to place before the submit before this court that you want to bring some documents with regard to this approval or letter.
I feel that there is no need of submitting any more documents actually, because I have come against the non-action of the authority for 5 years as per the provisions given in the Act. That is my grievance actually. For which 5 years we are suffering, we are not getting the due amounts, due unemployment allowance. That is the grievance. No impugned order specifically is there, because for 5 years, every year they did not. The illiterate people, they did not. After 5 years only, they tell, oh, we have not got. So that's how they have come. The grievance is for not getting the 100 days of work per year, all these 5 years, my lord.
In 2016-17, Lordship, work orders we issued to the VEC.
All the lists
but
have been
because
made from 2016.
of the dispute among themselves, the work could not be carried out. That's why after the election only, they came to the court gave them direction to conduct election. So it was conducted in 2018. Thereafter, the new VEC was constituted. And thereafter, we issued the work from time to time.
But then the lapse there, 100 days complete was not given. That is the thing, as per the given in the Act. For 5 years, maybe somebody got 99 days, but 1 day was less. Somebody got 78 days, 22 days less. So that less amount only for that only unemployment allowance is meant for. We are claiming that only. The number of days, 100 we have not got. We got 99 days. The extra 1 day we want. That way only, which is given in the Act. That's all, my lord. We want nothing else. What is given there?
They did not get maybe 100 days because...
Yeah, some days, the list is there.
Some of them they did not apply for work from the BC, or they did not attend the work.
The list is there. List is given by the learned friend only.
We have
from that only we have made out that somebody got 22 days, didn't get the other day. Somebody got 90 days, 10 days they did not get. So it depends upon the different persons. The claim is also that's why different. So number of days they have missed. Their claim is the unemployment and
Lordship, it's like this. How it worked. After the VC submitted their application for work, the Block Development Office generated the
procedure is accepted. That has been going on from before also.
Generate the muster roll and hand over to the VC. The VC thereafter they carry out the work, and after completing the work for 14 days, then they submit the muster roll to the VEC or to the Block Development Office, and then the Block Development Office feed this muster roll in the MIS, and thereafter the wage is paid to the job card holders.
No conflict on that matter. The procedure is accepted. That is the procedure. We accept that. Well, everything is fine. Only thing is that instead of 100 years every year, we are not getting 100 days every year. Some days are less, and for which unemployment allowance is granted by the Act. We want that only. nothing else.
That is available to. I mean, the basis should. I mean, the credential should be that you should be a job card holder.
Job card holder, yes, my lord. Others cannot claim.
So every job
card holder is given to one job card holder to one family only.
Yes.
In the name of one member.
One house.
Whatever.
One household, one job
One
card.
card, yes.
So you see, if you are a job card holder, and suppose you are not given work, or you did not voluntarily go to work for 100
Then
days.
we don't get. That is not the case here. We have been getting works. Works have been done in the village. Roads have been made. But our thing is that we have not got the exact 100 days of work every year. That is the thing. Few days we have got less, for which unemployment allowance is granted in the Act. We want that.
In the muster roll, everything is
everything is
indicated.
clear in the muster roll.
Everything is clear.
Who got how many days?
How many days? Who
Yes,
attended
clear.
the work? How many days? Everything is
clear in
given
the
there.
muster roll,
In muster roll.
produced in the court also.
One job card holder. How many days he attended
Yes,
the work?
yes.
It's given
That is
in the
there.
muster roll.
So in accordance with that, the deficit days only we claim unemployment allowance for those days only.
So you have made that claim. You have made that claim. That claim has to be made before the as per.
No, because the
as per
5 years consolidated, there is no procedure.
As per section.
There is no procedure laid down in the Act for claiming 5 years consolidated. Like it has happened. After 5 years, illiterate people coming to know that they have not got 100 days of work. Now, this kind of when lapse is there for 5 years,
Then another
there is
issue.
no procedure. in the
Another
Act.
issue will come up. What about if you have come after 5 years? What about the issue of forfeiture?
Illiteracy, the matter of illiteracy and the lack of knowledge of the rural people have also to be considered, my lord. They do not know reading and writing.
Is there
They
a
will believe
rule?
whatever the video says or whatever somebody says. We're in the dark about it. When they come to know, they have come to the High Court because there is no procedure for under the Act for so many days together to go and apply in any other forum.
The rules are there, Lordship, for unemployment allowance and so also for the
Yes,
delay
the
of
rules-
payment wages.
the
The
rules
rules
are
are there.
but
I have
when
closed
it
my
comes to a
affidavits.
lapse of 5 years, there is no procedure laid down. So they had no other way but to come to the High Court only with a writ petition, my lord.
Issue of delay and latches and waiver has to be looked into.
When the alternative remedy are available
There is no
under the rule,
alternative remedy for this specific 1 year.
one
They
should
could have them.
first exhaust the remedy and then come before.
There is no procedure laid down in the Act for such a remedy. That is why a writ petition had.
That was the query of the court in the first instance.
Yes, yes.
And if there is a remedy prescribed, then you should have avail of that remedy.
Long back. It was because of the ignorance of the people, illiterate people, it got lapsed. When they came in contact with me, a lawyer, then they have come to know. So at this point, there is no procedure for claiming 3 years or 4 years or 5 years through the proportional. No procedure laid down. That's why they have to come with a writ petition, my lord. There is no other alternative.
Lordship, he submitted that he has filed he has approached the DC under section 14. But there's nothing on record to show that
not
he has
this,
filed his
that is what is
any
not-
complaint
not
for the
this one, not in this.
before the DC.
Earlier to this, there was a writ petition filed by the same petitioner. He had come to that. Actually, what happened, as he said, 2017, there was a lapse in the works because of clash in the village. Another person by the name of Arbik village became the self-styled headman. He brought a list of 300 job card holders, false names, many, dead people's names also there. So against that, this petitioner had filed a writ petition 213 of 2010. In that, the court had ordered that fresh election be there, and after that, the new headman will be, new VEC secretary will be selected. Accordingly, new headman was selected. He was the secretary selected at that time. Then he filed this case. And before going to the previous writ petition, he had filed one to the DC.
But not in this case.
Not in this case.
The earlier case is for
No, that was for the election of the
conducting
headman.
election of the VC.
Headman's conflict was there. That was resolved. Now here he has come not for 1 year. 1 year procedure is laid down. A few days, 15 days, etc. procedure is laid down. But when the lapse is more than 3 years, etc., there is no procedure laid down in the act. So he has no other way but to come with a writ petition.
See,
There are two
Mr.
things
Bora,
here.
it is incumbent upon you. They may have, okay, let's assume, but not admit that they are illiterate or ignorant, and on being advised by the council or by anybody for that matter, the first approach, you should have taken recourse to section 14. See, look at section 14G. The provision is very,
that is the for redressal of grievance, but that
is the grievance. See, not being paid the allowance is a grievance. So they should have pointed out before the proper authority, and if that grievance is settled. If not, then you have you have recourse to come before this court or any appellate authority.
Now here it is annual affair, not accumulated. This is nothing given to redress the grievances of the applicants. Grievances can be of any type during those 100 days of work given.
Whatever. Here it did not specify as to what is the role or the authority of the district program coordinator. It is only stated that, only provided that he is to redress the grievances of the.
Now this the procedure followed there was the grievances were always told by the villagers to the BDO. BDO is supposed to transmit it to the DC. That was happening before. Now the people were unaware. They were thinking we are getting job, we are getting okay. Then when they came to me, when we calculated, okay, some days are deficit. Now this was found out in after 3-4 years. Thereafter they had to come to, because now here they non adherence to provisions of the statute gives rise to a right to file a writ petition.
Exactly.
A writ of mandamus lice.
Exactly.
That is what they had come with.
But the initiative should be taken by you. You should have taken the initiative to ensure that your rights have not been trampled.
No, the fundamental rights have been infringed because their livelihood has been infringed because they have not got the money. Now, the project coordinator has no right regarding fundamental rights or to redress fundamental rights
We are not talking about
infringement.
We are not talking about fundamental rights here. It's a question of your legal right, whatever.
Yeah, this legal right happens to infringe my fundamental right. That's why I have come with writ petition. Non-following of a procedure laid down in the Act or the provision laid down in the Act gives right to a writ of mandamus. Okay. We have come on that.
So you start.
Compliance of the provision of the statute. I can bring so many Supreme Court rulings are there. The non-compliance of the statutory provision gives right to a writ of mandamus, because the state had not done. Now, this officer does not have the right to redress infringement of fundamental rights. So that cannot be called the alternative remedy.
That will be discussed. So you start. Place your case in proper format.
I think it. We have. That's why we have prayed from a writ of mandamus.
Exactly.
That the non-compliance be corrected by compliance of this part, so that my fundamental right is not saved.
See, when you submit before court, you have to explain to the court how this thing came about. Where did it start? How did it end? What eventually compelled you to come before this court? What are your grievances? What is your prayer? You have to enlighten this court on that. Now, from what I've heard, is we're just discussing on certain issues and certain points.
Shall we be allowed to file a written argument then?
You can do that. Eventually, you can do that.
Yes,
but first, you make a oral submission.
Yes, ma'am.
then you can do it. Because in your
Yes, madam.
written submission, you can cite
Put everything
authorities.
in there, yes. So
that
that
can be.
justify my stand, yes, yes, my lord. We'll file written argument in that case.
Yes, Mr. Harvey.
Lordship,
Three weeks time maybe.
Mr. Bora submitted that he had approached the authority in the section 14, but there is no pleadings
No record, I know.
on that.
This is not in this case.
Nor
Earlier
any
cases we had.
application is there.
He has retracted.
I'll bring out everything in my
He has
argument.
retracted. He said that it was not in this case, but the other case.
We're not impugning any order or anything. We are coming in the general act provisions actually. So,
you
3
file-
weeks time maybe.
You file your written argument, and Mr. Harvey can reply to that.
Yes.
Or you
first
you
will
file
reply
your
to that.
simultaneously. It's up to you.
Here, Lordship, the prayer of the petitioner, Lordship, is for payment of unemployment allowance. The claim, Lordship, unemployment.
The only issue here is whether it's justified or not.
Yes, Lordship.
That's the only point.
Lordship, I'll just reply. Unemployment allowance, Lordship, my humble submission is that the claim is baseless, because after the election of constitution of the VEC, the Block Development Office had issued the work orders from time to time, Lordship. Till recently also.
But
From
the
time to
provision
time.
of the act is
let
that.
me submit. From time to time. Because in my affidavit also I have enclosed the work orders, Lordship. I have enclosed all the work orders which we have issued
That is not
from
under dispute.
2018 till 2020, 2021 or
Yes,
22.
that is not under dispute.
We have issued the work order. That is unemployment allowance. He cannot say that he did not.
We will have to go by the law.
There is the
Law says if 100 days are not given,
Mr.
deficit
Bora,
days.
Let him submit.
We'll file written argument, man.
that the work were not given to them. Another claim is that and if at all, Lordship, there is
He can reply to the written argument, my lord.
and if at all, Lordship, the claim is genuine, Lordship, there is a procedure laid down under this act, under section 14. Also, there is a rule, Lordship, unemployment allowance rules, which
Claim
I've
for-
annexed in my affidavit. The provisions are very clear, Lordship. The
So,
provisions and
we'll
let
file
me
written
complete.
arguments, my lord. That will be the
provisions
best.
are very clear, Lordship. In my affidavit, which I have filed, signed by the Deputy Commissioner, Lordship.
They are
The
not in
provisions
dispute.
are very clear. Unemployment allowance rules 2012, section 3, entitlement of unemployment allowance. It's there specified
are
there.
not on
Procedure
dispute.
for
This
filing
is
of
there.
claim. Procedure for filing of claim. Section 4. And section 5 is procedure for verification of claim. And after that, procedure for payment of unemployment allowance. If it is genuine, this section 6, it lays down the procedure for payment of unemployment allowance. That is there, Lordship. And then with regard to the prayer, second prayer, payment of delay payment of wages. Second prayer is
Delay
payment.
Delayed payment. Compensation for delayed payment.
Delay payment of wages. That also, Lordship, there is a rule. A rule which I have enclosed in my affidavit only. Same affidavit I have enclosed. It's compensation for delay in payment of wages. But my lord, here the wages are paid to the job card holders immediately after the completion of the work. The wages are paid within 2 or 3 days, and it is paid through a digital system by e-transfer to the account of the job card holders. So there, if there is any delay, Lordship, it will reflect in the system.
That is why
It
these
will
are not on
reflect in the
dispute.
system, because the muster roll are issued to the, after the work order, the muster roll are issued from the BDO office to the VEC, and then the VEC carried out work, and after completion of the work, the muster roll is submitted to the of Block Development Office, and thereafter, Lordship, this muster roll is entered in the MIS, and from there, after that, the wages are transferred, are paid by e-transfer to the account of the
that is the
job
norm.
card holders.
That is the norm.
No
That is
dispute
the-
about this procedure.
how
That
it
is true.
Done. And in my the wage list also, it is mentioned, it is shown the date of payment of the date of release of the wages. It is shown here. It is mentioned everything, Lordship.
Everything is there. That is not in dispute. That is okay, fine. So we'll file written argument.
Yes, so how long?
Written argument.
How long?
3 weeks.
3 weeks. Parties are heard. The learned counsel for the petitioner has submitted that the written argument will be allowed to be filed along with the authorities relied upon by the petitioner. Similarly, Mr. H. Gharmi, learned additional senior GA, has also submitted that the respondent may be allowed to file the written argument. As prayed for, list this matter to 3 weeks.
Obliged. In my written submission also, Lordship, I'll mention the paragraph, relevant paragraph in my affidavit. and
Whatever,
also
you can elaborate in your written argument.
Obliged.